Meeting for Kirk Farm. I'm Christina Sorrento. I'm the Chief of the Intake and Regulatory Coordination Division. And your lead reviewer is Ugo Njeze. The purpose of this meeting is to answer any of the questions you have based upon the comments you received. This meeting is being live streamed and recorded. I'm going to ask Ugo to highlight any of the major items we should discuss and then turn it over to you. Go ahead, Ugo.
Morning, Ugo Njeze with the County Planning Division. So again, the review for the Kirk Farm pre-preliminary plan application.
Can you hear him?
The biggest consideration and review topic is the stream valley buffer. Following environmental guidelines and also considering the Patuxent management area. Next would be trying to reduce imperviousness on the site, feeding, fire, and rescue regulations, and also potential dedication for MCDOT. Following the building restriction lines as well, the 80 feet separation between homes and showing the BRLs on site. But the environmental guidelines and adhering to that is the biggest. So, turn to you guys, ask any questions.
Sure, thank you. For the record, my name is Steve Crum, representing the applicant in this application. We think that we've demonstrated that we cannot get access from Tall Timbers Road. There's not enough frontage. We can't obtain, we've requested easements from two of the adjoining property owners. Neither one is interested in granting an easement that would give us access from Tall Timbers. So our only means of access is from Brook Farm Drive. We believe that we've shown the minimum fire department access, 20 feet wide pavement. We accommodated the fire department access flare at Brook Farm Drive, and we've provided a 90-foot turnaround outside the stream valley buffer between the two lots that we're proposing. So we think we've met the requirements for minimizing the imperviousness in the stream valley buffer. We note that the table 6 addresses 4 BMPs. However, that table is titled possible, which implies to me that it's not a 4 item. You have to meet all 4 of these items. It's that these are possibilities that are optional. We believe that the ultimate developer of the property will have to address that, but that what we've proposed doesn't unnecessarily violate those BMPs. With respect to fire access, I believe we have met that. And with the setbacks that we've shown, we do meet the 80-foot separation between the two proposed lots, and we meet the 80-foot separation between the Tall Timbers lot and the adjoining lot on Tall Timbers. We will certainly amend the plan before it goes to the planning board to demonstrate that, but we do have 80 foot of separation in both cases. Yeah, we appreciate the thoroughness of staff's comments. A number of these things will need to be addressed at the time of preliminary plan and probably by a future developer. The heirs that are submitting this application intend to try to sell the property, but we do want to have the planning board weigh in on the access and the flag lot requirements.
Any specific questions about anything you want to discuss now? That's a good way to.
So area transportation says revision requested. And they had two comments. One was that they weren't supporting access from Brook Farm Drive, and the second was to submit a traffic impact statement. We can certainly submit the traffic impact statement. I'm pretty comfortable that a 2-lot subdivision isn't going to exceed the 50 trips. Fire and rescue also lists revision requested, but Marie's comment was submit a fire department access and water supply plan. Again, we believe that whoever files the preliminary plan of subdivision will comply with that. Park planning asked for revisions, but they acknowledge that there is no impact to parks. They are just commenting that they support environmental planning. So,
Why don't we start with FCDOT's comment first? It's Deepak, are you on the line?
This is Billy Whalen. Our comments are kind of contingent on the other agency's comments. If access is allowed off of Brook Farm, then we'll need a proper turnaround there. If access is off of Tall Timbers, then you'll need the dedication. And there's a question as to whether what's the current paving will meet fire and rescue. So you'll have to meet fire and rescue comments as far as the surface and possibly repaving back to meet existing paving. I'm not sure where it is, but if you look on Google Maps, there's paving, and then it appears to go to kind of a gravel surface. So, but that's contingent upon fire and rescue comments.
understood. Our intention is that, or our position is that we don't have enough frontage on Tall Timbers to gain access. We understand from the concept plan review that Tall Timbers does not meet fire and rescue standards. And that's why we're proposing access from Brook Farm Drive. This is just a driveway. We are providing a turnaround that meets fire department standards. We don't see any public good in dedicating for Tall Timbers, but if that becomes an issue, we can certainly dedicate the portion of our property that would be that Tall Timbers would require.
Okay,
I apologize if there were questions for me. I had connection issues. I'm here.
There isn't, Marie, there isn't a question. I mean, your comment was submit a fire department apparatus access plan and water supply. There are abutting mains. Worst case scenario, we might have to add a public hydrant, and we would certainly do a flow test on the existing mains to make sure that there's an adequate flow. But we think it remains for a future developer to actually submit the fire department access plan.
Okay.
Any other comments that you saw that you want to flesh out? Or getting more specific about the site?
I spoke to DPS zoning about their comments on infill and, my understanding is that residential infill compatibility only applies to existing lots, not the proposed lots. I think Matt agreed with that position. So I'm hoping that those comments will go away.
Hi, good morning, Steve and everyone. Can you hear me okay?
Yes.
Yes, we spoke yesterday, Steve and I looked into it and got back to you, and no problem. The EBL does not apply. I pulled this up under the neighboring lot as a plat. So correct, for parcels, the EBL calculation is not required. And the secondary notes were minor, just an adjustment to the development table on your cover sheet to add accessory structure setbacks. Great hearing from you, and thanks for your question yesterday. DPS zoning has no problem recommending this for approval from zoning. Thank you.
If you have a question, how do you propose across the stream valley? Is there going to be the driveway through?
Well, there'll be a culvert to convey the stream, and there will be head walls to minimize the disturbance to the stream valley buffer. So there will be retaining walls that will serve as head walls for the culvert to minimize the disturbance. We wouldn't grade out at 3:1 and put flared in sections on the culvert.
Now, when I'm looking at tall timbers, I know that there is some fire rescue issues there in the concept, and you also can't get easements. But did you explore that 14-foot access point you have off the side?
It's only 14 feet, and therefore it's not wide enough to meet fire department access if we get two lots. And I think Marie's comment at concept stage was even with one lot, you need 20 feet.
I believe that when this came as concept plan, and Marie's here and she can talk more about this requirement, you will only, for one lot, you will only need 12 feet wide driveway to access just one lot. So she's here and she can talk more about the requirements. So Marie, can you please chime in?
So the discussion that's been had is for two lots. Steve's absolutely correct. For two lots, we've because it's essentially a division of the property that's there. Yes, the 20 feet becomes necessary. If there's documentation out there that we can prove that this piece of land, whatever it is called and however it is recorded in the land records, if it existed with the intention of having a house prior to 2010, then it is considered an existing condition for fire department access. So to get one single lot, if you document and we can figure out and we can determine that, yes, this was always supposed to have a house on it, regardless of how it's recorded, then we could pursue looking at an existing condition and leave basically fire department access becomes a non-issue. If that documentation does not exist or you pursue two lots, then yes, we're going with this is a new condition. This is a new, never intended to have a house on it. Therefore, we're increasing the density and housing in the community. And now current fire department access applies. So it's more homework has to be done in one direction or the other to go with the narrower driveway.
I understand the comment.
And I know this is pretty preliminary, so what you're looking for is finding language from the board. But I think the important exercise right now is what they're going to consider, talking about crossing the stream valley. So if there are options to avoid it.
Aren't options for two lots.
Steve, this is Doug Johnson. Let me shed some light on this. I'll be upfront with you. The board cannot issue a binding decision on access because they don't have all the information in front of it to make that decision. I've done this in consultation with our attorneys. The problem
Can you
becomes,
elaborate on what's missing, just so we kind of get a sense of what's you need?
the problem becomes that if the board were to grant this binding decision saying yes off of tall timbers, when it gets to the forest conservation plan and you have to request a variance for that access, that variance cannot be granted because you cannot meet 2 of the 4 requirements to grant the variance. So that puts a board in a rather precarious position. So what will have to happen is we will condition that request of yours. And most likely something to the wording of access off of Brook Farm is acceptable pending any review under 22A or the environmental guidelines. But the biggest hurdle, Steve, is going to be granting of the variance request. Right now, I don't see it happening because you can't meet all of the 4 requirements of that variance.
Those aren't requirements. It says the title of the table is possible. Doesn't say requirements.
Here's what the law says, Steve. Under 22A21, subparagraph D, minimum criteria. A variance may only be granted if it meets the criteria in subsection A. However, a variance must not be granted if granting the request and then the 4 requirements, 1, 2, 3, and 4. You can't meet 2 and 4. So right now, I'm just giving you a heads up. The variance is not in play right now. But because it isn't, the board cannot make a full binding decision on access off of Brook Farm. I'm just giving you a heads up that we're going to condition it.
Okay, well, this is Jody speaking. So condition it, but there is a possibility of satisfying those conditions. Yes.
Well, I'd have to work out the exact language with the attorneys, but it'll probably be something to the effect that access is acceptable if it meets the requirements under 22A and the environmental guidelines.
But you're saying we can't meet 2 of those requirements.
Right now, I cannot see meeting 2 of the 4 requirements, and it has to meet all 4 of the requirements.
Jody's sitting here because when the Wozniaks came to me, they said, look, we tried to get a reduction on the real property taxes on this property because we had made inquiries and been led to believe it wasn't going to be able to be developed. And the response was, you have enough land there for 2 acres, for 2 lots, and therefore that's what we're going to assess it as. So they've been paying taxes for God knows how many years when the assumption can be developed as 2 lots. And what I'm hearing is you're going to get no lots. And that's a taking of the property. And that's why I'm here, is to try and convince the planning board to avoid that situation by coming up with some kind of a reasonable, practical crossing of that stream that's livable for both of us.
Jody, what I'm hearing is that you could get 1 lot. You can get 1 lot using the existing access.
We have to be able to demonstrate to Marie's satisfaction that this property was always intended to have at least 1 dwelling on it, and it's a parcel, so it was never intended to have a dwelling on it until you go through the subdivision process.
For Marie's purpose, it's different than what we, when we look from a subdivision purpose, would be looking at it for. It's different, but that's what I'm hearing is that you could get 1 lot potentially here, but not 2.
But to do that, we essentially would have to bring tall timbers up to the standards that should have been imposed on the property on all of those lots when they were originally developed, including basically a bulb at the end and an adequate amount of structure. I mean, we're being asked to pay for a shortcoming in the approval of that subdivision just to be able to get 1 lot. And you just can't justify it from our point of view.
I think since this is pretty preliminary, I think a nexus discussion can be had about that. And proportional discussion can be had about that.
I mean, if you're suggesting that we can be sitting down trying to come up with some kind of crossing of the stream that minimizes the impact this guy's ready to go.
I was talking. I mean, talking about the improvements on tall timbers. So, once again, this is pre-preliminary. It's not as if this is.
You heard Bill Wellen. He's given you the shortcomings of that street, and you're asking us to correct all of those when they should have been imposed originally when that subdivision was approved.
Billy, are you still on the line?
Is that,
Yes.
Yeah.
So with the tall timbers improvements, you want to go all the way up to Brook Farm, correct?
no, it's whatever, Marine would need for, to meet fire access.
And Marie, if we go to the 2010 standard, how much improvement would you need on tall timber?
At the very least, it would need to be paved all the way back out to, I'm sorry, Brook, whatever. So the hydrant already exists at the end of the street, so that would be there, and then some sort of a turnaround would need to be figured out. But we wouldn't have to widen out to 20 feet because of the water supply at the end. So essentially, it would fall into a performance-based design category, but it would absolutely need to be paved for a minimum width of 12 feet all the way back out to the main road. And then a hydrant at the end and a compliant turnaround would need to be located somewhere, either on the property or in the right of way. I don't know how that would work.
Well, only, I think we're being told there's probably not a likelihood that we're gonna be able to come up with some kind of a crossing of the stream that you folks would be able to accept, that you could support. So I guess we have to go to the planning board and try and convince them that this is a taking of the property otherwise, in which event, try and apply practical standards of the guidelines rather than what Doug is telling us is a binding standard.
So how come you're not interested in pursuing the one lot? It's not a taking if you can have one lot, so I'm kind of confused by that, Jody.
Well, I would say simply because the amount of things it takes to make it a buildable lot are, I think, beyond what would be the normal subdivision requirement for a lot. I know as I was driving down, I was saying, Malcolm Shannon is going to be saying, Jody, what are you bitching about? You got one lot. So I understand that point, but it's just sort of inconsistent from what the client's been being told for, I'm going to say 15 years in terms of what the development potential of the property is. And I don't know the quality of that stream, but it just strikes me that we're elevating its importance to something greater than what this case justifies.
Jody, all that stems from the Patuxent River Master Plan.
Yeah, sure.
State in which then all of those requirements filtered into the environmental guidelines for the PMA. Water quality is plan.
Okay, please, let me get their attention.
So that's under the environmental guidelines. That's how all that shakes out, and the environmental guidelines for PMA is there's no disturbance of stream level. That's under the environmental guidelines.
Can I say something?
But the more important issue is the upcoming variance request and proving that you meet all four requirements of the variance request.
Yes, Miss Elizabeth, we can hear you and see you.
I just want to make a comment because they mentioned of being taxed for two. My parents have been taxed for 3 lots at the rate of $773 for 3 lots on this property over the last, I believe, 15 years. And I notified them and said, this seems excessive. I don't think they're going to get 3 lots out of it. And they said, well, this is how we tax it, with the possibility of 3 lots because our 200 zoning is a half acre zoning. So just to clarify that point, that they have been paying taxes on this for 3 lots.
I understand what you're saying. I think, unfortunately, we have nothing to do with the taxes, and so maybe that's something Jody can help you sort out in some way, shape, or form.
Well, my goal had been hoping that we could avoid having to have debate before the planning board on this subject and try and work it out in advance. And if what Doug is saying, just, hey, my hands are tied, there's not much I can do. I guess there's not much more value, any more discussion. There just has to be presented to the planning board. We'll both make our pitches and see what they think.
So you think that paving the street for to a 12-foot width is too much? That's the concern?
We've been told by the neighbors that they're not interested in having the roadway improved. Now, granted, it's a public right of way and we could go get a permit and do whatever's necessary. But for one lot, it seems that it's just not financially feasible to do all that. I don't know how we would create the cul-de-sac at the end to satisfy the public standards, even for 12-foot width.
Well, Steve, it's my understanding, forgive me if I didn't understand Marie correctly, she didn't want a cul-de-sac. What she wanted was a acceptable vehicle turnaround.
Billy Whalen wants a cul-de-sac because that's the standard turnaround for DOT.
No, it can be a hammerhead if we're talking Brook Farm.
Now, we're talking tall timbers.
No, it would just have to be something to meet Marie's requirements. She said it could be or Marie, a hammerhead would be sufficient, correct? And you said it could be on their property, wouldn't necessarily have to be in the right of way. Is that correct?
That would meet my needs, yes.
Well, just to chime in here, I don't think the neighbors there want any kind of paving or turnaround there. The one particular neighbor does not want anything there. So our hands are tied in this.
It's a public right of way, though.
Tall timbers is a public right of way up to
the point.
up to the end. But there's no, satisfying Marie's hammerhead turnaround, I don't know how that then satisfies that it's a public turnaround.
So in lot 14 at the end, on the south end of Tall Timbers was platted, they were not required to dedicate anything. So basically, it's absorbed the land area where you would have had be able to put in a hammerhead. So the hammerhead has to go completely on our property on the 14 feet of separation we've got. So, and the Jurassi's that politely told us that we don't want to have anything to happen out there, so don't ask us to cooperate anyway. So the only way we would have been able to do a classic hammerhead would have gotten them to agree to dedicate what should have been dedicated originally for their property, and then use that to create the hammerhead, and that land area won't be available to us.
But it sounds like you could, you have fairly large property here. It sounds like you can do it on yours.
But we have to get the easement. We have to get the easement from the neighbors.
Not if it's on your land.
Well,
You can go with 12 feet.
I'm saying that the amount of land area that our lot fronts on Tall Timbers is that 14 feet there. And that's just not enough to get the hammerhead to all work.
Do we have to satisfy DOT, wouldn't we have to dedicate the hammerhead?
Not if
it's on.
Well, how does the public turn around when they make a wrong turn down Tall Timbers?
they do it now.
Well, they probably use people's driveways.
Well, I think what DOT, what I'm hearing from Billy is he's saying you need to meet Marie's requirements, and Marie is telling you you could do it on your property.
Understood.
So
When we get to the point of permit, someone at DPS is gonna say, this is a public turnaround. We understand that it also serves fire access, but it's a public turnaround. We want that to be maintained by the public. We want the public to be able to use it.
But we're still talking about pre-preliminary. So we're talking about planning board binding decision.
So this is Deepak with DOT. So the turnaround need to be in the public right of way. It has to be dedicated. Cannot be in a private.
Thank you.
So maybe some dedication on the property, but it's a lot of property, to Christina's point. So again, if there are options, the board is gonna know there are options.
We understand that it's our case to make.
it sounds
Can I
like,
just- Could I just ask a question? Because my understanding is that the access is 12'2" and people keep talking about 14 feet.
14 is how much land we think the lot fronts on Tall Timbers Drive. It's not the pavement, it's
Oh, I thought it. Okay, I thought it was 12 feet, 2 inches.
I don't think so.
Okay.
Somebody was saying something. There.
it sounds like we might need another meeting on this. If we want to have another meeting next, what is it, next Tuesday, we could do.
If you think there's
Why,
something.
why can't we just keep on talking about it right now? I'm sorry, I don't mean to butt in. But this is Joseph Wozniak, and I own part of this, I own part of this property with my sisters. And I'm just wondering why we can't just keep on talking about it now. I understand you're got a busy schedule, but we're zoned in right now. We're penciled in for this time right now. So
What time is it? All right.
Well, Mr. Wozniak, this is the time to ask questions about comments received on the initial of the application. So.
right, but our application was to come in off the other road. Somehow or another, now we're going back to Tall Timbers Road. The first time we had this meeting months ago, we were coming off of Tall Timbers Road, and you said we can't do that. Now we resubmitted something else to come off the other road, and now you've shifted us. I don't know who made the comment to go back to Tall Timbers Road, but now going back to Tall Timbers Road. Why aren't we talking about the one road that we resubmitted the plan for?
So, Andrew Hudson has made comments about potential issues with crossing the stream Valley Buffer and issues getting a potential variance for it.
Mr. Wozniak, this is Jody Klein. We're not going to come to a resolution today. If there's an opportunity to talk some more, Doug's got some good points that we just need to try and address, see if we come up with a solution. So I'm in favor of an idea of coming back next Tuesday if we think that there's some possibility to come up with a solution, because it isn't going to be worked out today.
Did you hear that, Mr. Wozniak? I'm sorry for the
Yes,
technical
yes, I
difficulties.
did. I'm not happy with that answer, but I'll accept it. So next meeting that we have, are we going to come to some resolution, or is it just going to be ongoing meetings?
My feeling will be we'll either have a meeting and have a solution that we can agree upon, or we're not going to come to an agreement, in which case the matter will go to the Montgomery County Planning Board to make a determination of what you're requesting to do.
Okay,
Fair enough.
okay.
I think we can give everybody a chance to look, as we discussed today. I think, we'll have a better opportunity maybe to, we've heard some of your concerns about this, so we can go back. Let's schedule something for next Tuesday.
I think we all agree, let's avoid having this arm wrestling match for the planning board, try and work it out ourselves at this level.
That's good to me. All right, everybody, thank you.
All right, thank you very much.